Okay. Good morning and welcome to a meeting of the Licensing Subcommittee of the California Paraprofessional Program Working Group. I can take roll. Brennelson.
Here.
Judge Harper.
Here.
And we're hoping that maybe some additional, the other members of the working group will be available to join. We do have 4 members of the public are attendees. I don't see any other subcommittee members, any working group members. So do you want to see if there's anyone who wants to make public comment?
Sure.
Okay, I'm going to take these. So if anyone from the public would like to make a comment, please raise your hand. Can you still hear me? I just took out my earbuds. Okay.
Yep.
I don't see any raised hands. So, and I don't know how much we can do. We don't have a quorum since we only have 2 of the 4 members. Maybe I can send a quick email to Stephen Hamilton to see if he's going to be able to join us. Let me just do that real quick.
I don't have his cell phone.
I do. I just texted him.
Okay.
And I sent him an email, so
Can we, without a quorum, we can't even meet, or can we?
I think
we just can't take action.
right. So I think we can meet and we can discuss, but I don't believe we can take any action. That's correct. And, you know, there was the idea of this subcommittee coming up with recommendations to bring to the meeting on August 31st. So did you hear back from Stephen, Julia?
Nope.
And neither did I.
Well, why don't we, if Julia and Judge Harper don't mind, let's just go through it, get their initial take on
Okay.
it together, and it'll be a quick.
Okay.
meeting.
That's fine.
So I'm going to go ahead and Julia, you've seen this, but I'm going to go ahead and share this slideshow we created. So, and we start just with a review of the eligibility requirements overall that have been adopted by the working group, these recommendations that have been adopted. There was the eligibility requirements. And as you know, initially it was just the JD or LLM or a paralegal. And then subsequently your subcommittee modified its recommendation, which was adopted by the working group, to allow certain LDAs that were qualified, just those qualified pursuant to Business and Professions Code 6402.1b. And that is limited to LDAs that have a bachelor's degree. These are the educational requirements that were adopted by the working group, and these are, again, the universal educational requirements for all licensees. Oh, great. Hi, Stephen.
Good morning.
Good morning,
Hi.
Stephen. I'm glad you're able to join us.
You made our quorum.
Good. I knew I had to be here today, but I had an attorney. Can you imagine an attorney that wanted to keep talking and talking? Even if I told him I had to.
So we're
I'm just shocked.
Good morning. We're just starting to go over the presentation, and I'm doing just a review of the requirements that have been adopted so far. As you know, there were educational prerequisites or licensing prerequisites that were adopted by the working group. These are the universal education requirements for all paraprofessionals that have been adopted by the working group. This is the training that was adopted, the training requirements. And the testing requirements. And these again have all been adopted.
Except the only thing I think that isn't clear is that we also said that the LDAs could not test out of things. They couldn't get a waiver.
Right. And this is a very high level overview. It doesn't provide that level of detail. And again, these are the moral character licensing requirements that were adopted. So now what we're looking at is the educational requirements. So when the licensing requirements were adopted back in February, the idea was that each of the practice area subcommittees would come back and make recommendations about the specific educational requirements for their practice area. And unfortunately, other than family law, we didn't get to meet with each of the subcommittees to discuss the requirements. The family law subcommittee did in June meet and come up with these recommendations. It was an expansion of what was just initially recommended. And we combined the family law and procedure and advanced family law and procedure. Those were each put in as separate 3-unit courses, but we just combined that, and it's 6 units altogether. And there's a presumption that the educational institutions will know how to divide up what's, when they're teaching what. So
you said that there was a presumption with the family law committee that the institutions would then figure out how to present this. Is that correct?
Right. And
Okay.
and I think that the idea was not that each of the subcommittees would necessarily provide detail about the content that should be required. It was more of just how many hours should be required, and that that staff would work with the educational institutions and with subject matter experts to develop what the specific curriculum would include.
I agree with that. And so thank you. I appreciate that.
Can I add something? I've had a conversation now with community colleges. Leah, I think I spoke to the folks that you have talked to, and I guess I had a sense when I spoke with them that there would be more guidance that we would give them instead of making each educational institution, but rather, we're looking at community colleges, and I think there's 12 or 14 that have a paralegal program throughout the state. And so I think rather than assume that each community college would come up with that, I think with respect to community colleges, at least, there should be some global assistance in terms of helping them out, because I don't know, since we hadn't gotten this far yet, I was unsure what to say. And, but I did get, at least when I was working on this with Stephen initially, my sense was that we were going to have some assistance in providing the structure for the curriculum to these institutions.
And I think that's the intent, and maybe I wasn't clear enough. I didn't mean that we would work with each individual institution. What I meant was that the expectation wasn't that each subcommittee would develop the specific curriculum, but that's something that once the program goes into the implementation phase, that staff would work with subject matter experts and in consultation maybe with some representatives of the community colleges to determine what the educational requirements should be, what the specific curricular requirements would be, and those would be universal.
Yeah,
that
the
sound
learning-
right,
the
Leah?
learning objectives, right?
Right.
We have to identify those working with subject matter experts, because really, I think we're going as far as we can go with the current working group in terms of getting into the real detail of exactly what the learning objectives should be for each of these modules. So that, I think, is the next phase. And that is what we would give the educational institutions. What are the learning objectives?
okay, yeah, I mean, I think we're gonna have to talk about that. Maybe we can do that separately, Leah, a little bit
Yeah.
about the conversation I had with them.
Sure.
So again, so as I was saying, and I think that's a really helpful discussion. But what I was saying was that the Family Law Subcommittee did get a chance to meet and discuss and come up with these recommendations for the hours required for education. The method that was taken with the other subcommittees was that the staff came up with preliminary recommendations benchmarked to the family law educational requirements. The idea being that this is the most complex practice area that's going to be licensed. And so that those would be as a standard. And then what happened is I sent out an email to the members of the subcommittees, and I think each of you got those, saying this is what is being proposed. I'd like to get your feedback, and I did get feedback, and in some cases, all of the subcommittee members agreed with the staff recommendation, and in others there were some varying recommendations which were included in the memo, which I sent to your subcommittee, and I also sent it to each of the practice area subcommittee members and invited them to come to the meeting today to provide information and answer any questions that you might have. And I still don't see members from any of the subcommittees. So I'm moving on to the next one. For the collateral criminal, this was the staff recommendation, and there was agreement from the members of that subcommittee. For employment and income maintenance, this was the staff recommendation, and I'm looking for the document where I have. Oh, here it is. The employment and income maintenance subcommittee, I didn't get any feedback on the recommendations, and so I presume that there's agreement with those. For consumer debt and general civil, these were the staff recommendations. One of the subcommittee members agreed with this recommendation, and another subcommittee member provided an alternative. So I'll give you a minute to look at this. And again, this is all in the memo that was sent as well as posted to the website.
I think I was the one that was in agreement, correct?
I don't remember. I could go and look at.
You don't have to.
Okay.
My recollection is I wasn't recommending anything different.
So can I ask a question? When the alternative was proposed of the 6 units, the reasoning was because it was going to include state and federal law that they have to study?
Right. So yes. Yeah. And Stephen, I'm looking now. You did agree with this recommendation, and there was a concern raised that there were a lot of complex issues having to do with state and federal law. So there was a recommendation to sort of change the name of the course and to increase the number of units.
What do you think, Stephen and Judge Harper?
And what I'm wondering about is if I can finish going through this, and then I sort of have brought them all together and we can go through each one afterwards. Sure. Is that all right if we do that?
Yes.
So that I don't have to be working with multiple documents at once. That would help.
Sure.
So similar for housing, for the housing subcommittee, there were a couple of people who agreed, and then there were 2 varying recommendations. And this is the first one. And again, this one the subcommittee member did provide course content, or as Leah was saying, learning objectives, which I don't know if your subcommittee wants to include this type of recommendations. It might be useful as sort of as an example, or if you want to say that those wouldn't be necessarily included in the recommendation, but that this would be information that would be used in developing the learning objectives. So this is one of the 2 alternate requirements, and you can see that this is 14 units. And then this is the other requirement. And I put a note here, and I think I forwarded you, or I sent you the email that I got, and about the objection to the including this learning objective about the benefits of demanding a jury trial. And this was something that Stephen Fleischman actually voiced at the last meeting of the full working group. And he just wanted to be sure that you were aware that he has this objection. So this is the last of the slideshow, and we can now, I've created a separate document that just had, rather than in the slideshow, it lays out just the specific so can you see this now? This. Right. And this is just the universal requirements. That's just a reiteration, just so we have it for reference. So there, for this family, collateral, criminal, and employment and income maintenance, there was not any varying recommendations. And Julia, maybe I'll let you take over the leading the discussion at this point.
Yeah, I just wanted to point out that I'm not sure about our JD students, but if we get paralegals, most, like, I cannot speak to every program, but I can only speak to our program. We do have classes in family law, and we do have classes in landlord tenant. So I would think, and you know, we had an expungement clinic for a while. What I'm saying is that if they have an increased amount, for example, family law and procedure, I think some students may be able to test out of maybe 3 of those units. I'm not sure. And then the rest would be something new to them. But the one that I was most interested in looking at was the, what was the last one, housing?
Yes.
It was, so there was the difference between 13 units for housing and 14. So that would make it the heaviest of any one of the subject matters. It would even beat out, I don't know, it just seems to me that that's an awful lot for landlord tenant.
And this is the area where Amos had sent the email asking that we defer action until was it this area that Amos had written to us about?
Yes.
Yeah, that's a memo he sent out. Yeah.
Okay.
I think that, like, as a threshold matter, if you all continue to agree that family law is the most complex area that the paraprofessional is going to be licensed in, then there isn't any other practice area that should have a greater unit requirement. So that's kind of, to me, conceptually, if that's still the belief, then, you know, out the gate, you would not do 14 units for housing, because family law is 13.
That's what I was kind of getting at. It's the most complex area, and probably the most utilized area is going to be family law. And so to me, looking at the 11 units seems to consist more with what the expectation, I think, is, and what Stephen and I, before Judge Harper became part of the subcommittee, I mean, we really are trying to get this done within a year so that it's attractive to students to put their time into it and move on and get a job doing it. So I like the fact that there's itemization of the areas they would like to cover. And I would, as a side note, like to see more of those kind of issues laid out before curriculum is developed. But I do think that it's very helpful to people to see what kind of issues we want them to have efficiency with. And I just cannot imagine that this should be 14 units based on what I know about it. The
I
11
agree. And I agree. And I think that's one semester's full of just that information. That would be someone who, if that's the amount of use they can even take, if you're really committing to that. And I think that'd be a lot of units. That really probably have to be divided over 2 semesters, which then gets you outside of that hope of doing this within a year.
When did we adopt the recommendations for family law? Was that before or after the vote for in-court advocacy?
That was, so the initial recommendations of just the 6 units, the family law and procedure and advanced family law and procedure, those recommendations were adopted in February. The additional recommendations for family, these have not yet been adopted. These are the recommendations from your subcommittee, the family law subcommittee, from the June meeting.
Yeah, so I guess where I would say is, when we voted, my recollection was we had voted on these before the in-court advocacy, and I had always been real clear that I was voting based on my belief that there wouldn't be in-court advocacy. Oh, how wrong I proved to be. So I don't know that it's fair to compare the metric for family law to housing in light of the fact one was adopted before in-court advocacy was adopted versus one was done afterwards. Does that make sense? Like I really want to stay within that 1-year time parameter.
I think it can be done, Stephen. Just remember, they have family law that they can take as paralegals, and you can take family law in law school.
Right.
And we do have the 3 units of court advocacy.
Yeah.
In the universal requirements, plus you have 6 units of family law and procedure. I think in the interest of making it look doable, we stick with the 13, and they just may have to be a rigorous 13. That's all we can say is.
Fair enough.
But I think the housing with 11 is adequate.
Can you scroll back down to the housing again? Thanks.
And I think the 2 recommendations are very similar. It's just the units are different. And the first recommendation doesn't really break out how that's divvied up in units either.
Yeah.
So collectively, we would just reduce the landlord-tenant issues down to 10 units is the suggestion.
I think it's 11.
10, but then
10, and then the lien clearing is 1, yeah.
Yeah.
And do you want to use the list provided in the top one, or to sort of have I think that there is, I think everything in under unlawful detainer is included in the first one.
Yeah, I agree.
Except for the benefits of demanding a jury trial. That's not included. And so we can just have it be landlord tenant and unlawful detainer and have it be 10 units.
I do like the COVID tenant protections law and tenant assistance. I think that's important to make sure is included while we're still in a pandemic.
Mm-hmm.
Yeah, I think Linda, we should make sure, because I think I don't see like the small claims court action. I don't see that. So I think if the direction is, let's put everything from the bottom list into the top and just make it 10 units. So there's flexibility.
Yeah.
That's a good idea.
I like that.
And rental assistance programs.
Well, maybe we can do that offline.
Okay, and then, and that we'll have it be 10 units. And what about this issue of benefits of demanding a jury trial? So that's the objection that was raised by Stephen Fleischman.
What
Do
was
you want
his
that to be?
objection? What was his objection based on again, Linda? Do you recall?
So what he said at the last meeting of the full working group on July 26th, he expressed a concern about the number of jury trials in eviction, in unlawful detainer cases. And he even asked Judge Rubin to contact his colleagues to get their input on whether they would want this to be taught. And he cited information that the half of all the jury trials in the Los Angeles courts are unlawful detainer trials. And he just, from what I remember, and Leah, tell me if you heard it differently, it sounded like he just expressed a concern that if this program and the education provided to paraprofessionals encourages people to file more unlawful detainer demands for jury trials, and that would be lead to further have an impact on the courts. Judge Harper, sorry.
So I'm on the housing subcommittee, and that is a concern, is that by a paraprofessional not being allowed to conduct a jury trial, that there's a concern that you're going to be at a disadvantage if you go to a paraprofessional and someone doesn't understand up front that that paraprofessional can't conduct a jury trial for you. So there's a very big concern that we need to let the people know up front that I can't help you at the jury trial level. You're going to have to either hire an attorney, or I can sit there with you, I can answer your questions, but I can't conduct the trial. So, and also there was a consensus that most tenant groups demand a jury trial. That's something in our county, we don't see that, but I think in the bigger counties, they see that, where if you're a tenant and you're getting help from a advocacy group, they're going to demand a jury trial up front. Doesn't mean they'll all go to trial, but that's going to be a demand. And so there was a concern that if you have a paraprofessional not being able to do a jury trial, that the person knows up front, hey, we think jury trial, there's a benefit to it, but I can't be the one doing it. So that, I think that's where that comes from, is really educating the potential clients that I can't do that jury trial.
I think that's a good consumer protection. I think
Yeah.
it's worthy of inclusion.
I agree.
I agree too.
Okay.
So, and I think this is a little different than Stephen's concern though, right, Linda?
Yeah, my understanding of Stephen's concerns is that it would further clog up the courts if we had more people requesting jury trials. That's what I heard. And did you hear something different, Leah?
No, that's what I heard. So basically not wanting this to be called out because of a concern that we're pushing jury trials and that is going to clog up the courts.
I don't see why we would have an interest in encouraging jury trials, since the people we are trying to employ can't do that work. I mean,
Well, I think if it becomes educating consumers about what the risks and benefits are, if you demand a jury trial, you have to pay for the jury too. That's something that can be easily explained about. I mean, it's not a lot of money, but it is an additional cost. And I think the idea of educating the paraprofessionals about how they can do this kind of risk benefit analysis for prospective clients or clients would be important.
Yeah,
So maybe
I
if we
agree.
change it benefits and costs.
Or maybe risks and
Risks.
benefits.
Yeah.
benefits and risks of demanding a jury trial.
Yeah.
Okay. Okay. That sounds good. So it looks like we've got housing done.
Do we
And
want,
just,
so
I'm
on the
sorry.
housing, so we're going to do this notwithstanding Amos's request to get a specific recommendation. I'm okay with that. I just want to be clear.
So I think Linda sent out the email to everybody and we got responses back. I don't know if as a time constraint, are we going to in that sense, you'd have to send it to all the subcommittees to get their recommendations. I think we were trying to avoid that. So I understand Amos's objections, but he had an opportunity to comment. Everybody had an opportunity to comment. And so,
And this is Amos's recommendation, this second one here.
oh, it is. Okay.
Yes.
Okay.
Yeah, so I think as long as the record's clear, we considered it, but because of time constraints and the need to get to a final report, we opted to go with his recommendation and then make it available for discussion to the entire group.
Right.
Okay, I'm good with that.
Okay.
Yeah,
So,
just 'cause can I ask one question? I mean, still, the whole group has to vote on this, right?
yes.
Yeah.
This will be a recommendation for your subcommittee, and it will go to the full working group at the August 31st meeting. And as usual, I will draft the memo from your working group, from your subcommittee, and get your feedback before it goes to the full working group. Okay? So the other one where there were differing recommendations was consumer debt and general civil. And just let me check in with you. Should we just go when there were not varying recommendations? Do we want to proceed? Are you agreeable with the recommendations regarding family, collateral, criminal, and employment and income maintenance?
I don't have an issue with either of those.
Okay.
I agree. I read through your memo, so yeah, I agree.
Okay. So consumer debt and general civil, again, there was a varying recommendations. And so I don't know if you want to take up a discussion on those.
And can you remind us, even though I'm in that subcommittee, what the reason, can you remind us what the reasoning was between the 3 and 6 units for debt collection and creditor harassment?
Yes, there was a concern for, in terms of the debt collection and creditor harassment, or that when it was just called collections, that there are varying and sometimes conflicting state and federal regulations regarding collections. And there was the idea that it would require more time to make sure that people are fully apprised of all of the different issues involved.
It seems to me you could cover that in a 3-unit class in a semester. I don't know why you'd have to have 2 3-unit
Yeah,
classes.
I'm inclined to agree with that now.
Where did the recommendation come from, the 6 units?
That came from Amos.
It just seems like that's a lot of awful units for that subject.
Yeah.
I'm wondering if he was thinking because of the federal law implications that they're going to have to be educated on those to know whether to, it kind of like that same analysis that we just discussed for housing, that they're going to need to be able to know about what the federal law and what the remedies are and why there might be a benefit to doing it. And I'm thinking specifically to some of the subject matter speakers we heard from on the debt collection. I remember there was the one attorney from the Los Angeles area that spoke to us.
I think that, I mean, the only thing I can relate it to is teaching, for example, civil procedures and litigation. That's a 1-semester course, and I focus a lot on California law, but I still do touch on the federal rules. But that's just the focus of our curriculum. And I think since they're not going to be in federal court, I'm concerned that 9.5 units would take probably a whole year, and then they would only be able to probably test out of one subject matter, consumer debt and general civil. I think if we keep it at 6.5, they could still do another subject matter that is one of the lighter ones.
Yeah, I agree, Julia. it just seems to me you could cover that information in a 1-semester 3-unit class. But I defer to you. I mean, you're the one who has a curriculum, so you know better than I do.
Well, I just know what you can accomplish. I mean, it depends what rigor you're going to put into it, but I think we're intending this is going to be a pretty rigorous program because they're going to be working in the courts. So I don't know.
Can we say debt collection and credit harassment for 3 units instead of 6? So it still has to recover that same
Sure,
subject matter.
that's a good suggestion.
I'm sorry, I got interrupted. Can you repeat that, please?
We're just saying that we don't know if you need 6 units for that. We think you can cover it in a 1 semester, 3-unit class, that same subject matter.
And instead of calling it collections, call it debt collection and creditor harassment.
And that's roughly the equivalent of 50 hours of in-class instruction. Julia,
That's my understanding.
Well,
13 hours per 1 unit,
I think that's what we were talking about. It's
40 hours.
yeah, 3 hours per. It's 3 hours per unit.
How many hours, Linda? It's the 3
Well,
unit.
if it's a 15-week semester, it's 45 hours of in-class instruction.
Yeah.
But the assumption in calculating the hours is that for every hour of in-class instruction, there's an additional 2 hours of student engagement with the material.
Yeah, so that's why I had that question, because I was working off in my head a 16-week semester.
So if it's a 16-week semester, it would be that much more. So, but just each hour really translates to 3 hours. Each unit translates to 3 hours per week of student engagement. So a 3-unit course is 9 hours per week of student engagement, times however many, if it's a 15-week or if it's a 16-week semester.
And of course, this is all going to have to pass muster with the accrediting associations that are used for the Western whatever schools to maintain accreditation through them. So whatever they would perhaps require of us.
Okay.
The area that was 6 hours from Amos's recommendation was the debt collection and creditor harassment, right?
Right.
Yes.
And I
Yes.
just changed that to 3 based on your conversation. Are you in agreement with that as well, Stephen?
I don't know that I need to go to 6, but I'm really thinking maybe it needs to be maybe 1 more unit. Thinking in my head everything that I've ever had to look at through the Rudder Group Enforcement of Judgments Guide. It's a 2-volume set. It's pretty intense. I think I'd be more comfortable if that one was 4.
I'm fine with that. Julia, if you're okay with that.
Yeah, I mean, it's going to have to somehow work out though for the institution on how they work with their units. I mean, almost every full semester course is 3 units. So kind of having this extra half unit and then adding 1 more unit to make it an odd number. I just am saying from a college standpoint, it's going to be confusing how to structure it.
So the other thing that I wanted to mention is that, do you think that the recommendation that you want to make to the working group would be that these hours that are included here are minimums and
Yeah.
that the institution could provide more hours?
I think that's a great recommendation, because then it shows that we really want to work with the teaching institution or the learning institution. That's because really all of this is going to have to pass through the Board of Trustees of Community College. And there's a long way to navigate still.
But remember that these courses will also likely be offered at least our California accredited law schools. I don't think we want each institution coming up with its own unit requirements. That would be kind of odd. Meaning,
Yeah.
like if I do it at a community college, I take 9 units, but if I go do it at this law school, I take 12 units. So I think it could be a minimum, but then there's got to be standardization at some point. So maybe it's a minimum And then the subject matter experts that the bar convenes, that includes the community colleges and probably representatives from the accredited law schools, and then subject matter experts in each practice area, they can adjust the unit requirements. But once they do it, that would be standard across all institutions.
That's a good approach. I agree with that.
Okay.
So where do we stand in this 3 versus 4 hours?
I'm still good with the 3 hours. I understand Stephen's recommendation before, but I think it can be covered in a 3-unit class.
And if it can't, then I think the people who are experts on developing this we've got to trust them to know what they're doing. Do you agree with that, Stephen, or will it?
I don't think we have to be unanimous. I said my piece, and the consensus is stick with the 3, and I'm okay with, I understand. Because I expect what I expect to happen at the general meeting is Amos is going to weigh in on this, and we're going to hear more details from him.
Yeah, I agree. I thought the same thing.
So I'm okay.
Okay.
Okay, great. So I think we've covered everything that we had intended to cover today. I'm just checking, and among the attendees, I don't see anyone from any of the subcommittees. So if you think, is there anything else that your subcommittee needs to discuss today before we develop these recommendations in writing in the memo to the full working group?
This will be for the meeting on the 16th, correct?
No, this will be for the meeting on the 31st. The 16th is going to be devoted just to the discussion of rules.
Okay.
Because that was at the July meeting, there was a request that we have
Yeah.
a full working group meeting just focused on the rules that were not included in the group vote.
Okay, good. Understood. Okay, perfect. I just wanted to check my calendar. I had to miss the July 31st meeting. I was in trial that day, but I won't miss the next 2. So that's good.
Okay.
I may not make it to the one on the 13th, but
The 16th,
The 16th is.
the 16th.
you're gonna miss the fun.
Yeah. I had way too much fun on the last one.
Okay.
Okay.
All right. Well,
All right.
thank you all.
Great.
Thank you. Have a great weekend.
Yeah, you too.
Okay, bye-bye.
Hey, thanks, guys.
Thank you.
Bye-bye.